Thank you. Professor Vladeck, I would note you're a very talented law professor and appellate advocate, and you said, gosh, Judge Boasberg followed the law. Well, he plainly disregarded the law regarding non-disclosure of senators, subpoenas targeting senators, but set that aside. Your defense of him is he didn't know. Well, if he didn't know, that's because Jack Smith was engaged in wild misconduct by not telling the judge. But apparently the judge didn't give a damn because he didn't think to ask. But let me just ask you, did Judge Boasberg have any factual basis whatsoever to sign multiple orders that says the court finds reasonable grounds to believe that such disclosure telling the senators will result, not may result, will result in the destruction or tampering of evidence, intimidation of potential witnesses, and serious jeopardy of the investigation? And I would note to you that the claim now is he didn't know who the hell it was. So did he have any possible factual basis other than a brooding animus to all Republicans and that all Republicans are criminal? Is there any other conceivable basis?
Senator, I haven't seen the government's application. Perhaps you have, and I don't want to risk delving into areas that are confidential. But without having seen the government's application for the NDO...
You're very clever. What do you think?
I mean, I can speculate that there was very likely information in the application, given that the grand jury agreed to issue a subpoena.
All right, assume for sake of argument there was no evidence, because Jack Smith said, I didn't tell them they were senators, so you're leaving out a lot of details. So assume, this is a hypothetical, you've argued in court many times, the hypothetical is the Department of Justice told him nothing. I believe that hypothetical to be true, but assume the hypothetical. Is there any basis for signing these orders over and over again without the judge saying, gosh, can you give me one piece of evidence before I sign this order?
So, Senator, you're asking me to answer whether the Justice Department provided no factual proffer and he approved the application.
No, I'm saying if DOJ provided no facts to support this, would Boasberg have any basis for signing it without any factual predicate whatsoever?
I mean, I think the question would just then become, what was the standard practice? And on that regard, I would defer again to the letter that
I don't care if the standard practice is to be lawless. My question is, you're a law professor. You've been an appellate advocate. As a judge, one day, if there's a Democrat in the White House, you may be a judge. That wouldn't surprise me at all. Would any judge have a basis for signing an order with zero evidence and saying, the court finds? Is that consistent with the judicial oath, yes or no, assuming the hypo of no evidence?
If the Justice Department had provided no evidence in support of it, then I would think that an order that nevertheless approved it would be inconsistent with the law.
I do as well. Senator